Hello, this is Mrs. Politsky, and I have notes for Chapter 5, Section 3, Business Law. What can a tort victim collect? So, what can a tort victim collect? Well, you can use an injunction. This is something that might stop a certain action of a business or a company. So, for example, if the company is putting out a product that is known to hurt and harm people, an injunction can be filed to stop the company from producing whatever the product is. Or you can take them to court and you can work towards receiving some kind of damages. This is a monetary award that is used to kind of compensate the injured party for any kind of loss. Some damages are just basically, to pay the bills. The others are meant to punish the party that is in the wrong, and we'll mention that here in a second. A contingency fee, anytime that we're talking about a tort case, typically lawyers will ask for a contingency fee. This is basically the whole line as you might hear on TV, we don't get paid until you get paid. The idea is that if the lawyer wins the case, they get a percentage cut from whatever is won. And so they usually try to push the damages to a higher dollar amount so that they can obtain quite a bit of money for winning a case. If those damages are meant to really financially hurt someone, they're known as punitive damages. And think about the prefix here, the pun. That's kind of like punishment. And so punitive damages are set so high that they're meant to punish the wrongdoer in these kind of cases. Okay, so if a court case, a trial case for a tort would go to the judge, you're going to see the following. You're going to have a judge that's going to decide the case. If there's enough dollars involved in this case, you'll probably have a jury. Civil cases don't always have the right to a jury trial, and part of that is because of the dollar figure involved. If the case is less than $2,500, typically it would go into a small claims court, and you don't have an attorney, or you don't have a judge, or I should say you have a judge, but you don't have a jury involved in that. You can have a civil, not injuries, but civil jury. There we go. Civil juries usually consist, depending on the state, anywhere between 6 to 12 people. Typically in Nebraska, we're looking at 12. They listen to the witnesses, they review the evidence, they kind of reach a decision. The big thing to remember is in a civil case, it doesn't have to be a unanimous decision. When we do have these cases, as in most court cases, you'll have opening statements. This is basically an outline of what the plaintiff, that would be your defense, and the prosecution, what they hope to set out to prove. There's evidence that's going to be handed out. This could be anything from written documents, records, charts, photographs, doctors, reports, all that, that can be submitted as proof. Testimony is a very common form of evidence. This usually comes from a person, and they usually give the statement under oath. Along with that, the witness themselves showing up in person to present their knowledge to the court in person. To get a witness to appear in court, you need a subpoena. And this is an order from a judge, usually handed out by a county deputy or a sheriff, stating that you are to appear in court to give testimony. If you don't show up and you have been subpoenaed, you can be in contempt of court. And that is punishable with a fine and perhaps maybe even jail time. So you want to show up. When the case is winding up, then you'll have closing statements or closing arguments. This is the last ditch appeal to the jurors. During the court case, you might find the attorneys doing a consultation. That might be talking to a client, or it might be asking questions of the judge. The decision that is made by the jury is known as the verdict. And when it's all said and done, the final result of the trial is a judgment. So how is a judgment satisfied? If the plaintiff wins, then the defendant, the person who's been accused, has to pay the judgment. If that person does not pay, the plaintiff can ask the court for a writ of execution, and it's the process by which the judgment for the money is enforced. Usually it would be done in a couple different ways. You could ask for, a stake in the defendant's property. So you might put a lien against their property. It could be by garnishing salaries. And what would happen is if I got a paycheck every week, before I would get my hands on my money, it would go to the courts. The courts would take a certain percent of that, and then whatever's left over, I would find in my account. Any questions? All right. Thank you very much.